George Oraro, Senior Counsel, George Gilbert, and those, Mr. Mbulua, and those who said that basic structure is in the Constitution, but is not applicable. Just to clarify, what does that mean? It sounds like a contradiction. The next clarification I seek, perhaps from Mr. Karori and those who represented the President regarding his role in popular initiative. If he's entitled to do so, why did he pass the baton to the promoters to finish the race? He would have gone all the way to the finishing line. Number 3, for, I think, the counsel who represented the Speaker of the Senate and the Senate, and I think Counsel Morara on the referendum question. My reading of the opinion of the Court of Appeal, Lady Justice Nambuye, Lady Justice Okwengu, and Mr. Justice Kiagi appears to me to have been unanimous that you must have separate and distinct referendum question or questions. Mr. Justice Gatembo seems to me also to have agreed with that position, save that he qualified it by saying, depending on the nature of the proposed amendment. Lady Justice Ichale did not express her opinion on this question. Mr. Justice Tuyot said the issue was not ripe. So therefore, if you look at the opinions of the judges, it would appear that the majority agreed with the High Court that you need distinct question or questions. And therefore, in my view, and I'm asking a question, if you look at the disposition, the final disposition on this matter, the court said they set aside the declaration by the High Court regarding the referendum question. So who are the majority? The majority, in my view, upheld the High Court. So if counsel involved in this can confirm that I'm right or wrong, then I'll be satisfied. The final one, really, I don't know whether there's a question. IEBC didn't seem to have addressed us, or I can't see in their submissions, the issue of the limitation of boundaries of the 70 constituencies. And yet I thought this really is directly on their role. So I don't know whether it was tact or it was strategic, but perhaps the counsel for IBC can tell us whether they have really no view at all regarding the second schedule. I thank you, Judge President.
Thank you. Judge Renal.
Thank you very much, and thank you, counsel, for your submissions. Judge Oko has picked on 2 of the issues I want a clarification on, but I have 3 others. The first is to the eloquent Dr. Eboso. Dr. Eboso, you made a very interesting submission that sovereignty is extra-constitutional, that it is not reposited in the Constitution, and that for that reason, the basic structure is implied and not express. And my question is, where then do we get this sovereignty reposited at? Is it fluid? Is it misty? Where do we grab it? Where do we locate it? I'm asking this question because you also made reference to the Kesavananda case. In that case, at paragraph 368, the court said, therefore, if any part of the Constitution was intended to be excluded from the operation of the power to amend, it would normally have found a place in or below Article 368, which is the amendment provision in the Indian Constitution. The court also said, then again, we find that when the people, through the Constituent Assembly, granted the power to amend, they made no reservation in favor of the people. The people completely withdrew from the process of amendment. So that if it is true, as you said, and Aluocher also said the same, that the people are sovereign, yet you are saying that sovereignty is extra-constitutional, what are you telling us? I need to understand that. The second question is to Mr. Kirago Kimani on the powers of the president to initiate a popular initiative. The question is there precedent elsewhere in your research where a president has initiated a popular initiative in a constitution similar to ours? And following Judge Ouko's question, therefore, how far should he have gone? And if not, what is the issue there? And tied to that, there was controversy right through from the High Court whether the President of Kenya in fact initiated this popular initiative. Are you admitting that he did? Or what is your position regarding the particular event? Did President Uhuru Kenyatta initiate this popular initiative, or another entity post his own actions initiated the popular initiative? And to Isaac Aluocher, again, thank you for your submissions. One of the issues that came through the Court of Appeal decisions was the finding by one judge that, in fact, the question whether we should have multiple or a singular question in the amendment bill was premature, because the IEBC, which is the body that is mandated to do certain things, had not reached the level at which it crafted any referendum bill. Are you then submitting that, in fact, Justice Tuyot, I believe, was correct in saying that the issue was premature? Or are you, Isaac Aluocher, saying we as this court should proceed and make a determination on the question whether, upon reaching the level of the referendum, the amendment bill, in your view, should have one question or not? So my question is the prematurity or not of the amendment bill. I thank you, CJ.
Thank you, CJ. Thank you for all counsel who have submitted thus far. I have a question to Mr. Aluocher. You've been very clear that it is the preserve of Parliament to legislate. And indeed, it is your position that the judges, therefore, in the High Court ought not to have read into the Constitution anything that is not in the Constitution. Yet, on the other hand, you've suggested to us that the bill that goes to the referendum ought to be in the format of separate bills, each having a different question. Looking at the Constitution on bills, Articles 109 to 114, from 255 to 257, there is no such detail. There is no such prescription of how the bill ought to look like. So I'm just are you asking us as a court who ought not to legislate to put in that prescription, or are you asking us perhaps, are you suggesting to us that it is Parliament that ought to put that prescription into on the issue of the bills? That's the first one. Secondly, you're very clear that the Constitution does not allow the President to use state machinery under Article 2.2. If you look at the presidential functions, could it be possible, is there a possibility that the President, in exercising the functions given to him by the Constitution, can indeed move amendments to the Constitution in order to achieve the functions given to him under the bill, like the unity, to unify the country, or any of the different aspects of his functions? In that situation, what would your position be? My other question then would go to Dr. Eboso. You talked a lot about the promoters of the amendments and how it should be an ordinary Kenyan who can go and look for the million signatures and start the process. Would, in your opinion, these promoters be restricted in eliciting support from politicians, from the President, from any other Kenyan? How, in practical terms, would you see the promoters moving to meet the requirements to collect the signatures and to process all the issues required up to referendum? And also to you, Dr. Eboso, what do you think of a proposition that the President himself can initiate legislation? And does he do this? How does government policy become legislation? Does the President initiate legislation? And if he does so, is it a possibility that then he could initiate the legislation that is the bill that would then accumulate in the referendum? Finally, this is not restricted to any party. I would just like to hear from any party that thinks that they may be able to answer this, about the 4 sequential steps. Are they expressly provided for in the Constitution? Are they implied, and where? That's all. Thank you.
Thank you. Justice Wanjara.
Let me also join my colleagues in thanking Counsel for your very elaborate submissions on the questions before us. This is directed to Mr. Karori and to a certain extent Mr. Oraro and also Gilbert. If I understood your argument correctly, you did submit to the effect that a popular initiative kicks in, a popular initiative process kicks in after the collection of signatures, if I understood you correctly. Now, if that be the case, if that be your submission, what is the basis of this argument? Because then you would have to tell us what is a popular initiative, what makes an initiative popular within the context of this provision, I think Article 257. So why would you say that the process then kicks in only after the collection of signatures? And then the next question, it touches again partly on what my brother Judge Oko asked regarding the basic structure, and this has detained the courts right from the High Court now up to the Supreme Court. Again, if I understood your submission correctly, again, this again goes to the 3 Counsel. You are saying that when you look at our Constitution, you can see a basic structure. In Article 255, that therein is a basic structure. What is inspiring that characterization? Why is it a basic structure? Why are you saying that the specific provisions to which you have referred, actually constitute the basic structure? then by the same token you argue fairly strongly that although that be the case, the basic structure doctrine, I think as understood from the Kesavananda case, is not applicable in Kenya. Why is it not applicable? What predates what? What inspires? Is it the doctrine from which your basic structure as you have identified it derives? Or is it vice versa? Or is the basic structure as you identified in our constitution something that falls beyond the doctrinal aspects of what we are dealing with here? And therefore that doctrine is not applicable. So those are the two questions. Because there could be a contradiction, but if you clarify, there may very well not be a contradiction. Why do we locate a basic structure in our constitution? And why do we, in the same vein, submit that the doctrine of the basic structure doctrine, however you call it, is not applicable in our constitutional setup? And Mr. Aluochiri, you may wish also to chip in, because your argument was not on all fours with the three counsel, but you did also say that the basic structure doctrine, as you understand it, is not applicable in our constitutional architecture. Thank you, CJ.
I would also like to seek as more clarification, just a little trajectory on this issue of the popular initiative. I think Justice Wanjara has asked when the process began. The clarification I seek is that there were processes that led to the setting up of the BBI task force and the steering committee, as well as the fact that members and staff therein drew remuneration from public funds. And then there is the question of whether, because of that, can this qualify to be a popular or people-driven initiative? That will be answered, I think, by Counsel for the AG. The second clarification on my part is on the public participation. So far, since the Constitution 2010, we have been guided by weighing whether there was public participation on a case-by-case basis. The matter that is before us, the matters of Chapter 16 of the Constitution, looking at the complexity, our history, I would like some information on how public participation can be undertaken in this regard. Would there be necessary for there to be put a legal framework or some rules of procedure to that effect? That is what I would like to ask also from Counsel from INBC who submitted on public participation. We'll give 3 minutes to each to respond. Each of the parties who have been asked to respond, please take about 3 minutes.
May it please the Court, Kirago Kimani for the 20th respondent. I'll try and deal with the questions from the two judges fairly quickly. But I think I'd like to give the context first. It must be borne in mind that the 20th respondent was not heard before the High Court. And the basis of the Court of Appeal decision was that once the Attorney General was disqualified, so to speak, from representing him. The court should have ensured, the High Court should have ensured he was served. Let's look at the questions now. And the reason I'm giving the context is that I stick to my lane. I have not looked at what the evidence was there on anything other than surveys. But I think it's fair to say that there's no admission that the 20th respondent initiated this process. And it's important that the court does hear something about what initiation means, because I think there's been a mix-up of the terminology. If it didn't initiate it, then there was nothing to pass on. There was no button to pass on. That's a long and short of it. But it's important that what the process entails is explained, and I think the persons best suited to do that are the 18th and the 21st respondents who say they are, or they were the promoters, so to speak. So I still have time, and I ask for them to nominate whoever will speak to this, because I think the court is entitled to an answer.
My ladies, my lords, I will answer that question, although I'll ask for some time later to make a few comments on the other issues that have been raised. The involvement of the president in this matter, I was trying to look through the gazette notices. Unfortunately, I did not get it, but they're on record that there were two gazette notices. One gazette notice that set up what was the BBI task force, and a second gazette notice that set up what was the BBI steering committee. And the words that are used in those gazette notices asked both the task force and the steering committee to look into administrative, policy, statutory, and constitutional measures that may be taken in order to secure national unity. So first and foremost, it was not a direction towards recommending purely constitutional changes, but it was an invitation to consider whether there were constitutional changes that would be necessary if one was pursuing a measure towards uniting the country. And it is from both reports then that particular recommendations were made to say that, yes, there are constitutional amendments that we can make that would help in securing national unity. And the matter ended there after the president received both reports. It is the BBI National Secretariat that has described itself as an alliance of political actors that then took up and decided to pursue those constitutional amendments by way of a popular initiative. And therefore, the real promoters of the popular initiative then are the people who styled themselves as the BBI National Secretariat, who are the 21st respondent in this matter. Thank you.
If I could go back to my Lord Justice Lenaola's question, whether there's precedent in other jurisdictions. First, the starting point is that I could not, for the life of me, find anything that qualifies the president's right to do this for the reasons we gave earlier. But so therefore, I did not go out to look for this. But the Attorney General's submissions have actually given us examples, not of president, but political parties, political groupings. So when you do take time off to consider the submissions, the Attorney General has dealt with this at paragraphs 57 to 59 of their submissions. That's a first petitioner. And they've given the clearest example, which is Switzerland and what has happened, and it's nothing unusual.
Yes, my Lord, still on that issue that my learned friend, Mr. Kiragu, has just submitted on, just looking at an example of a popular initiative that has originated from a head of state, not a president, but a head of state. There's example of, it's a difficult word, Liechtenstein, I think is the word. The Article 64 of the Constitution provides for popular initiative, and in a referendum that was held on 14th of March 2003, actually initiated by the prince of that country. The referendum was initiated.
Which country, Mr. Karuri, which country?
Let me spell it.
Yes.
It's a difficult word to pronounce. Liechtenstein. Yeah, that country. My lord. Yeah, there was a referendum that was held on 14th of March 2003. It was initiated by the prince of that country. It had asked voters to approve an extension of the power of the prince to, among other things, nominate judges and veto legislation, and the referendum was passed. My Lord, while I'm on my feet, I think I should just answer the question asked by my Lord Justice Wanjala on whether when the popular initiative kicks in. It is correct, my Lord, that I did say that the popular initiative, the provisions of Article 257 are only engaged once the 1 million signatures have been collected. And the reason for that is obvious, that people will come up with all manner of ideas. They can try to popularize that idea, but if it does not, if 1 million registered voters don't sign up, don't support it and sign up, then the provisions of Article 257 are not initiated. In other words, my Lord, put it plainly, because I know my Lord has been a lecturer, so let me put this as plainly as I can. If you do not get the 1 million signature, you have not popularized your idea. It is not popular. It only becomes popular when you have collected the signatures of 1 million registered voters. I hope, my Lord, I've answered the question. Thank you very much.
You raised a very important question on why we say the Constitution has a basic structure, but the basic structure doctrine does not apply. My humble submission, sir, is that every Constitution has a basic structure which form the foundational parts of that Constitution, and where that basic structure is not specified in the Constitution, then it is the role of court to find out where it is. Within the context of our Constitution, historically in the making of Constitution, this is a matter which was addressed by the CKRC Commission, and at paragraph 746, it was recommended that a number of key constitutional issues should be entrenched in the Constitution, and they could be amended only by a referendum. So it did two things. One, it identified those key foundational parts of the Constitution and included them as thematic matters under Article 255(1), and further prescribed how those provisions can be amended. Now, there was the question which was raised by my Lord Justice Ndungu on whether what is the basis of the 4 sequential steps which were included in a decision by the High Court and the Court of Appeal. The 4 sequential steps were the original basis upon which the Constitution was amended. It is neither included in any legislation or constitution under the current framework, but it arises from an interesting constitutional theory which Professor Albert talks of in his constitutional amendment and dismemberment, and this is what he says, that the theory of constitutional dismemberment suggests a default procedure to legitimate dismemberment. Here, when the Constitution is silent on the distinction between amendment and dismemberment, the deep constitutional transformation that dismemberment entails can be legitimated, with a few exceptions, only by at least the same similar configuration of constitutional making bodies that made the commitment that dismemberment later seeks to undo. So if, sorry, my time is up.
Yes, your time is up.
No. For clarification, there cannot be time.
Okay. It's okay. Carry on.
So if it is intended to amend the basic structure and the Constitution doesn't provide a means of doing that, then you have to revert to the original basis upon which the Constitution was made. And that is what the court was trying to do. But in our case, that has been prescribed under the Constitution. My Lady Chief Justice, if you wish me to address the issue of public participation under Chapter 16, which you raised, I can also address it. But I would like to defer to your directions on whether there's time to do it. Yes. Now, under Chapter 16, you begin on the basis that Article 1 reserves the people's right to directly participate in exercising their sovereign power. And under Chapter 16, Article 266(2) has expressly provided that in constitutional amendment, there has to be publication and then public discussion. That's the only article of the Constitution which includes public discussion. But that is not without prejudice to the public participation in every step of legislation which, in popular initiative as we have here, commences with public participation before the county government discussions, then through Parliament, and thereafter voter education by IEBC under Article 88. And the whole of this process is to ensure that the public are given sufficient opportunity to debate the issue, discuss it before it is passed by their elected representative, and thereafter finally endorse it.
Our answer is wholly on what Tuyot J.A. Summarized it very succinctly at paragraph 251 of his judgment, and he says, these provisions, and more specifically subsection 2, places the responsibility of framing the referendum question to be determined on IEBC. In this instance, IEBC had not received the request to hold the referendum, and occasion had not arisen for it to discharge its responsibility of framing the question. Further, it had not been suggested that IEBC had already determined the manner or the formula in which it would frame the question or questions in respect of the referendum touching on the impugned bill. It cannot therefore be fair, and he proceeds. It was always our argument in the Superior Court that the High Court had acted totally without jurisdiction because it acted as the Supreme Court providing an advisory opinion. The High Court has no jurisdiction to provide an advisory opinion. And that question was not ripe, it was moot, and it was not open to the court. Finally, on the second question of my Lord Judge Ouko has asked, what is our view about the proposed change in the mandate of IEBC in the creation of these constituencies? And our position is very straightforward. Our powers are not what some of my colleagues are calling basic structure. I'm calling entrenched provisions. The powers of IEBC, its mandate, is not entrenched. Its mandate can vary, can be amended, can be modified, can be by Parliament in its wisdom, by the referendum process, as whatever. So that we did not feel that it was necessary for us. If you give me
finish.
2 more minutes, because I wanted to offer purely gratuitously an opinion on the basic structure. So we did not feel like, if I may say this, my lady, this court has a jurisdiction that is very, very clear to hear and determine presidential cases. This court has another jurisdiction to hear and determine matters of great public importance. Just supposing, a bill was created seeking to take away the second part of your jurisdiction. I think that you may express yourself in the process of public participation, but you cannot, in my humble opinion, take the view that it is unconstitutional. And that is the position we took. Let me say something about basic structure, because I think there is a little confusion there. And I think from where we sit, basic structure means that part of the Constitution that cannot be amended because it is specially protected. Normally, it is specially protected from Parliament. The Basic Structure Doctrine Act operates in parliamentary system, if at all. And India was a good example, because you are stopping a transient parliamentary majority from fundamentally altering the basic law. In Kenya, what my colleagues have been saying, and what I support, is this. The drafters of the Constitution identified what was so precious that Parliament should not be left to mess around with it on its own. They then protected that. And that is why they are saying there is a basic structure in the Constitution. Thank you.
My lady, the Chief Justice. My lady, the Chief Justice, you raised a concern about the question of public participation. So to associate myself with the submissions by learned Senior Counsel Mr. George Oraro, just from the perspective of IBC, that there is a decision, a locus classicus from this court in the decision of BAT, which then sets out the principles on which public participation is supposed to be conducted. It is our submission, my lady, that that particular decision fits very well on all fours with the provisions of Article 257. And so that the question of public participation under Article 257 can be achieved in an incremental basis, so that 257.1 on the question of the promoters, the courts agree that there is a limited public participation for the promoters to know what the bill is about. Then at sabbatical, that is Article 257.6, when the bill is sent to the county assemblies, again, the courts agree that it is not for purposes of changing the content of the bill. It is for the county assembly to then get an opportunity to consider the bill. So again, at that point in time, there's public participation. 256.7, again, at the National Assembly, there's an opportunity for public participation at that national level. And then finally, there's an opportunity for public participation in the referendum. And in the referendum, my lady, it is our submission that the IBC will have a role under Article 88.4G of the Constitution, which speaks to voter education. Other words, explaining to the voters how the process is supposed to be conducted. So it's a continuum. I'm most obliged, my lady.
My ladies, my lords, I'd asked permission to make 2 comments after the intervention I'd made. One is on the issue of the basic structure. And I want to refer back to my submissions yesterday when I talked about the romanticism that accompanies the word's basic structure. And I say the word's basic structure are not supposed to reflect something you go looking for in a constitution. It would be in the words we use when we talk about the spirit of a constitution, when we talk about the Grundnorm of a constitution. You really cannot take any particular text of a constitution and start saying that you're looking for its Grundnorm and say that it will be found in this article or in this section. Neither can you very specifically start looking for the spirit of the constitution. I think position we are is that the word's basic structure, much as they are used to reflect a theory in constitutions, in constitution making, they have unfortunately been imported to almost be a legal tool that can be used even in litigation. And I am saying that when you think about the word's basic structure, you must also think about whether you can give similar significance to the word Grundnorm and go looking for it, and whether you can give similar significance to the issue of the spirit of the Constitution, which is always talked about. But I have never seen any court specifically go looking for a spirit of the Constitution in any particular articles. On the issue of the referendum questions, my opinion is that there is always a mix-up when we talk about referendum as it is in the Elections Act and referendum as it is in Article 16. And there is a lot of mix-up between the referendum as you discussed the two. For instance, the phrase about framing the question is a very specific phrase that relates to a referendum that is conducted under the Elections Act. And it talks about an issue arising. The issue is taken to Parliament, which approves that the issue should be taken for referendum. And it talks then about IEBC framing the question that will represent that referendum. And for IEBC determining whether the issue to be resolved by referendum will be resolved in one question or in two questions. But if you go to Chapter 16, when it comes to amendment, there is no issue of raising questions when it comes to Chapter 16. And Chapter 16 talks of taking the bill to a referendum. So there are no questions. And if there would be a question, it would be a vote on whether you accept the bill or not. That is one perspective. But the second perspective would be that you cannot have single items taken to the people, because a lot of issues that have to go into constitutions are negotiated. In fact, very many, and I'll give the example, if imagining that the current constitution had been taken as different questions for adoption, one can immediately begin to imagine how many things would never have passed. Is it possible that with all the noise that there was, that a Christian majority would have gone and voted in for the protection of the Catholic courts had they been separate questions? So the idea of not allowing separate questions is because then constitution making becomes, you remove the negotiation from constitution making and make it a question of majority vote. While sometimes you need to tell the majority that they will not get what they want unless they accept what a minority wants. So even in public policy, they have to be separate questions. And lastly, on the four sequential steps, my opinion of this is that this was pure legislation from the judiciary. There is no reason, and I said yesterday that the assumption that having a constituent assembly is the best practice in constitution making assumes that it's a universal practice. We have not yet accepted that making constitution through constituent assemblies is actually the best practice in the world. So for it to be recommended to Kenya would be, was it because it's a best practice internationally, or because that is what the judge thought is what the way should go? Thank you.
Your Lordships, so that I defend my position, first of all, I associate myself fully with all my seniors who have submitted on that line. But in regards to the issues that were raised, and specifically I'm one of the people whose names was mentioned, I would like to draw the court's attention to, there is an authority provided by Mr. Orara Moke in his submissions as paragraph 8, Supreme Court of India in the Reserve Bank of India versus PLS General Finance and Investments Company Limited, 1987. It says interpretation of the Constitution must depend on the text and the context. Now, you asked a very important question, why we think Casavananda is not applicable in the current situation, and I'm going to point out that it does not match either the text and neither does it match the context. If you look at the Constitution of Kenya, and it is unique and interesting that Senior Counsel Githu Muigai has submitted on the parliamentary system of application of the basic structure in relation to the Indian Constitution. And yesterday I provided to this court that is provided for under Article 368 of the Indian Constitution, which is the exact kind of parliamentary system that is predicted under Article 256 of the Kenyan Constitution. The Indian Constitution lacks in substance Article 255(1). The Indian Constitution does not have Article 255(1). And therefore, on that ground alone, there is a difference in context. If you come to the both context, there's a difference in text. Now, if we come to context, which again marry with text, we find that the Kenyan Constitution, on a very distinctively different path with the Indian Constitution, introduces the referendum. The referendum is not a provision of the Indian Constitution in any way. Looking and considering that path of the referendum, it means the power has been thrown back to the sovereign, to the people. And therefore, the issue of contradiction is not that we were saying that there is a basic structure and again say it does not apply. We were saying the basic structure is that provided by 255(1), but there is a submission from our opponents, which have gone on from the High Court to the Court of Appeal and soon coming before you, that there is another supra-constitutional, extra-constitutional powers that provide another element and elevates another thing called the basic structure that is different. So we are saying that theoretical kind of basic structure does not exist because our Constitution provides for that basic structure under 255(1), which gives the power to the people. And therefore, we submit that there is no contradiction at all. We have a basic structure. And that Constitution has also confirmed the context, and the context was well expounded in Kivuitu, when Kivuitu, the case that we mentioned yesterday, said very well, and I repeat, we agree with the sentiment expressed by Rengera J, that an amendment that upsets the structure of the Constitution could not be effected by Parliament without involving the people. So the court realized that there's an amendment that can upset the structure of the Constitution, but as long as the people are involved, you can still amend that. Just one line so that I sit down and rest in terms of the multiple questions or one question. It was my submission yesterday that is, as far as I'm concerned, an immature matter before the court, because the IBC had not reached there. Therefore, if any court, the High Court or the Court of Appeal, pronouncing itself on matters which were not yet ripe, maybe the courts will be sitting in another jurisdiction offering advisory opinion, rather than sitting on real matters of facts that should be determined. And even if the court again makes a pronunciation to confirm that, then the court will be, as currently constituted, is not a court that offers advisory opinions. I rest with that, Your Lordship.
Thank you. I think we'll hear from Dr. Oganda. We are giving 3 minutes. I think something went wrong with our timer, so that we don't rehash what was said in the submissions, just to focus on the answer. Dr. Oboso. Sorry, Eboso, sorry.
I'll quickly go through. The 4 sequential steps are not expressed in the Constitution, but they are implied. My submissions to the Supreme Court, I have demonstrated how the popular initiative has public participation all through the process, right from starting from the collection of signatures. And in the collection of signatures, the person convincing 1 million people definitely is taking the views of these 1 million people, and they are saying, we support this. Constituent assemblies do not have to be named constituent assemblies. Constituent assemblies are any body that is elected for the purposes of amending or reconstituting a constitution. The county assemblies, therefore, being elected, and even the National Assembly being elected, conform into a constituent assembly when they are considering an amendment to the Constitution. And then, of course, we have a referendum. So the 4 steps, they may not be sequential, and they need not be sequential, but the 4 steps are implied within the Constitution. Can the President initiate legislation? Yes, he can propose legislation to Parliament, and there is a framework for that. I captured that in my submissions to the High Court, that I think the standing orders permit a cabinet proposal to be tabled in Parliament. Secondly, the President issues State of the Nation address every year and an address to Parliament. Through that, he'll be making proposals to Parliament on what to do, but the President cannot himself legislate. Same way, the proposal by the task forces under the President could have been made and taken up by anyone to pursue a popular initiative. The problem in this came from the fact that the national executive put resources now to support it through now the collection of signatures in terms of using state resources to collect signatures. And that's where the problem came in, that once the President proposes it, then it is up to anyone to take it up and use their own resources, do whatever they'll do as individuals to pursue it. Can the promoters are the promoters restricted to seek help from politicians? They may seek help from any other person that is not the state. A constitution defines the relationship between the state and the people. Anybody who is not the state would be considered the people. Civil society and so on and so forth, they could come together and move. Even political parties, to the extent that they are not part of the state, can do that. The problem comes in when state resources now are put into this, or it becomes a state project to amend the constitution, because the state is what is meant to be limited. The nature of sovereignty, really what you're asking is who is the people? Because the sovereignty is really, we've said the sovereignty belongs to the people, so it's the people who are sovereign. But what is the nature of sovereignty? Now, sovereignty is both under and extra constitutional, in the sense that it can be under, and when it is under the Constitution, I think my time is up, but yesterday I had 1 minute left when I presented. I'd like that 1 minute now. I'm on the last question, though. The nature of sovereignty is such that above the Constitution, you cannot define sovereignty. You can only know that it exists. It's like the concept of God. You can only understand the God who's described in the Bible or in the books that we are given. But you can't know God beyond the books that you're given. So sovereignty in this state, we can understand who the people are under the Constitution because they are defined. But above the Constitution, we can only know that they are there. And they can manifest in a coup. When a coup happens and the people accept the new government, that's the sovereignty that has accepted that government. And so above the Constitution, you can only recognize or give legitimacy through the theories of recognition of law, not through the Constitution. And that's why I was saying, under the Constitution, the only legitimacy we can give is that which has been done in accordance with the Constitution. So the nature of sovereignty, I talked about it in my submissions at the High Court extensively, and I think some of the authorities I gave on the nature of sovereignty would assist in that. Thank you.
To Justice Lenaola, issue of multiple or singular questions in a bill, the rightness issue or premature and all that. What the Constitution of Kenya Amendment Bill 2020 was a bill which had several issues contained in it. And because a bill was already presented and we're dealing with the bill, that issue was not premature as such because we're dealing with the bill. And therefore, because we're dealing with the bill, we have to consider what should be contained in that bill, and it is a consistent message in Chapter 16 that only a single issue can be contained in that bill, as it was a bill that was presented to the people of Kenya. I'll now move to Lady Justice Ndungu. Whether or not we should have legislation in Parliament to legislate whether we have a single question in a bill. At this stage, because we were presented with a bill prior to any legislative arrangements on the matter having been put in place, I will suggest it is not necessary. It is a question of this court interpreting Chapter 16 in relation to the Constitution of Kenya Amendment Bill 2020. Chapter 16 is consistent with only a single question in a bill. We had at least 74 different questions in the Constitution of Kenya Amendment Bill. So therefore, this court should nullify that particular bill on that basis. It wasn't constitutional. It didn't comply in terms of consistency with the Constitution. A third question was whether if the functions of the president include, for example, pursuing national unity, and in his opinion, he felt that he needed to have the Constitution changed to aid him in the pursuit of national unity, would that be permissible? I will suggest that if you look at the Constitution as a whole, in a holistic manner as opposed to in a piecemeal manner, including Article 259, Article 159, including the spirit and purpose of the Constitution, I think we have in our Constitution all that we need. When we give the President his functions concerning the things he's supposed to do, and we give him this is the Constitution, these are the rules by which he should play at, that is more than sufficient. I think in this particular case, since that was the case before this court, I think the principals, meaning Uhuru Kenyatta and Raila Odinga, had additional purposes of pursuing. They wanted to change the executive. They wanted more space for more politicians. In their opinion, that would kind of quieten the tensions that we normally have every 5 years. That was the opinion. But then, if all of us are willing to accept the electoral will of the people through an election, we accept it, we respect everybody's opinion, everybody's entitled to an opinion, that's already in our Bill of Rights, we don't need to have those kind of mechanisms. In other words, what I'm saying, what we have in our Katiba is sufficient already to do the job of a president. We don't need to change the Katiba for the president to be able to do additional things he wants to do. I mean, if he's doing his job, it's sufficient. If he wants to do additional things, that is different. He puts a proposal and we consider it as appropriate. Thank you.
Thank you very much. We'll now move to the next segment of the hearing, and we'll start with the third appearance. Just hold on. I think there is a question that was not answered, and Judge wants to follow it up. Just a second.
Thank you again. Lady. Perhaps this may be raised, may be answered by Counsel Morara, perhaps when he comes next. But I had asked those who are together with the appellants whether the majority decision in the referendum question was indeed the majority decision. I didn't get any answer. Perhaps we can hear from Mr. Morara, but I had intended it to go to those representing the appellants.
If you're not ready, you can do it in your response. The appellants can do it in their response. We can have this time now given to the third appellant. You have 1 hour, although I realized that you were donated some time, and I think the timekeepers know the time which was donated to you. If you need it, it will be given to you.
My Lady the Chief Justice, the President of the Supreme Court, Honorable Justices of the Supreme Court, it's almost afternoon, good afternoon. My name is Topua Lesinko, and I appear together with Mr. Morara Omoke, and Ms. Margaret Kamau and Mr. Justice Nyaga on behalf of the third appellant. Before my lords and my ladies, I introduce our submission, and with the leave of Mr. Omoke, we did note that deliberate effort by the first appellant and the IBC to ignore the question by the Honorable Justice Ouko, and we note that the third appellant did indeed submit a letter requesting for review of the holding of the Court of Appeal, that particular issue of separate and multiple question. And I think your position is really qualified by the finding of Justice Gatembu Kairu in paragraph 197, Roman 4, where he just said that I do support the separate and multiple questions, but subject to the proposed amendment. So in our opinion, we thought that he was together with the three other judges, including Justice Nambuye, Justice Patrick Kiage, and the President of the Court of Appeal, and therefore it should actually have garnered the majority. But that notwithstanding, he will deal conclusively on that issue. In the course of our submission, we shall be relying on our submissions file on the 6th December and dated 24th November 2021, and also volume 21 of our record of appeal dated 15th September 2021. I shall be submitting on the first and second issue, namely the applicability of the basic structure, doctrine, and popular initiative. And just to flag this, I shall answer all these questions in the affirmative that indeed it applies. Also, towards the end of my presentation, I will attempt to provide a response to the various questions that have been asked. My colleague, Mr. Omoke, will be covering the following 4 issues: the constitutionality of the second schedule of the amendment bill, the place of public participation under Article 10, the issue of quorum of the Independent and Electoral Boundaries Commission, and whether Article 257.10 envisages a separate and distinct referendum question, though we filed this appeal reluctantly, noting that it was indeed an error by the Honorable Judges of the Court of Appeal. My ladies and my lords, today we appear before you to defend the Constitution of Kenya against a coup d'etat by the trustees, the political elites, who were bestowed with the solemn duty of protecting, preserving, and upholding the Constitution. At the end of every election year, the president is sworn into office, and I personally have never been present physically in those events, but if my mind serves me right, one of the things that is normally given is the People Charter, the Constitution, or what Professor Guy calls an imposition by the people on the political elite. At the end of the 5 years, the president is required to deliver that baby, the Constitution, back to the people, alive and kicking, not a dismembered or disfigured Constitution that lacks identity and its structure. Indeed, if I had the liberty to characterize the current proceedings before you, my lords and my ladies, I think I will name it the people versus the constituted powers. And we are going back to, I think, the eras that scholars like Professor Nabweze in 1984 in Presidentialism in Commonwealth Africa, Okoth Ogendo in his article Constitutional Without Constitutionalism, published I think in 1993. It was a book chapter widely available, where they were decrying the overarching power of the imperial presidency. So that is exactly where we find ourselves today. And I will just, before I delve into my submission, correct submission by Mr. George Gilbert, trying to distinguish the issue of the basic structure doctrine. Mr. George Gilbert actually attempted to distinguish the basic structure, and he did agree that the basic structure is applicable pursuant to Article 255 and the basic structure doctrine. And I am comfortable, either my lords, to use a basic structure and not the word doctrine,
And I note actually the definition of the word doctrine as defined in the Oxford Learner's Dictionary is just a belief, a set of belief. You are not actually sanctioned or to use it mandatorily. You can actually ignore. But I'll argue towards the end of my submission that because of the issues of constitutionalism and what Professor Rosnai says that we are in an era where executive powers are constrained, that even in the express requirements that amendment of the Constitution is limited, the same can be implied. It's my submission that our history, our text, and the context, and I know that Your Lordship, under Section 3 of the Supreme Court Act, and based on the concurring decision of Mutunga in advisory opinion number 2 on the Senate, he says that this honorable court has an elastic power to not only look at the context, but the history. And our history today is the amendments of 1966, for example, that did away with the Majimbo system, ultimately returned under Article 255 on devolution, and this is actually one of the ring-fenced provision. It's one, another thing is the issue of, for example, fair trials, which were germane in the President Moi and President Kenyatta, founding President Jomo Kenyatta era. So it's that history of amendment that the people wanted to undo. And at the beginning of the agitations for reform, especially in 1992, I know that there was a Kanu Review Committee. And later, jumping to 1997, during the IPPG, the people actually coerced to say that we are not accepting the IPPG because we must be part. And I think ultimately it led to the People's Commission and the Mfungamano Initiative. And so the people wanted not only to have control of the content in the Constitution, they wanted also to have control over the process. And the process in this regard is popular initiative provided under Article 255 and 257. Therefore, the intention was very, very clear that they must not just be part of the menu, but they want to be present in that table where the Constitution is being promulgated or made, or in this case, because I do concede that the power of amendment on consequential issues was given to the constituted powers, but not on the substantive issues under Article 255. So, coming back to Mr. Gilbert, and maybe Senior Counsel Paul Mwangi, Attorney General, and George Gilbert, they discussed the origin of the basic structure to be an importation from Professor Conrad in Germany to India, and now mysteriously finds itself in the corridors of justice in Nairobi. And which actually I think Professor Rosnai, just after the High Court judgment was released in May 19, 2013, characterized it as a, just a minute. Interestingly, he used a very interesting title. He said that the basic structure doctrine arrives in Kenya, the winds of change for constitutionalism in Africa. And that was barely 6 days after the High Court gave that judgment. And in our submission, we've argued that it's not a new concept. Justice Ringera in the Njoya vs. Republic case in 2004 alluded to this in detail and discussed the constituent power of the people. And I think the people also, under the commission, review commission, I think 2005, if you look at page 76 of that report, of the final report of the CKRC, there's a very interesting commentary that is provided of what will ultimately come to mutate to be Article 255. So there's a very important paragraph. The Attorney General has cited it. It's paragraph 7.26 of that report. And you could actually see that the whole issues, including supremacy of the Constitution, independence of the commissions, including the judiciary, issues relating to devolution, have been ring-fenced. And so for me, I think, and I do agree with the findings of the High Court, paragraph 471, providing that the foundational features form part of our basic structure. And the people have actually clearly outlined that under the CKRC report. So my ladies and my lords, it's my submission that based on the submissions by the first appellant and those in support, this court is left with two choices on the issue of basic structure. The first choice is for the court in relation to agree with the submission that the basic structure doctrine do not apply, which is our submission that it applies. But in the case that this court goes along that tangent of argument, it's our submission that as considered by Mr. George Gilbert that it has a basic structure. So take away the doctrine, they've agreed that it has a basic structure. We have, in relation to the argument that it has a basic structure, based on the aspiration, vision, spirit, and the textual wording of Article 1, that the people are sovereign and they delegate some of the powers to the judiciary, executive, and parliament in trust, the people still retain the residual power on the most fundamental things under the Constitution. And that, for me, I think it's Article 255 and Article 10, which I think has attained what in international law is termed as jus cogent. But equally, I'll add the Bill of Rights to that, which I think is very important. So, therefore, that even if you take the basic structure doctrine, the argument still stands, and the first appellant and those in support agree that it indeed has. And I will be highlighting that even in the High Court judgment, the Attorney General did in fact agree at some point that the basic structure doctrine applies. It's only that goals have been shifted, including even in the question of who the promoters were, which I'll be dealing later. But that still leaves their case exposed. If your lordships and ladyships agree to the finding that it has a basic structure, which is a reflection of the aspiration and vision of the people, then the argument will be that Article 255, 256, 257 exist to limit amendment of the Constitution by constituted powers, not by the ordinary mwananchi. In that regard, I fault the first appellant submission and Mr. George Gilbert's submission again, to the effect that, and the wording they used was that the Court of Appeal, the Superior Court, misconstrued in finding that the Constitution limits the power of amendment. I don't think it limits. What they will have done, they will have continued and says it limits the amendment of the Constitution by the constitutional powers, and these include the President and any other state officer. That means that if this court was to arrive to a different conclusion that it was not the President who commenced the popular initiative, and which I don't think they have the leeway to do that, because the question presented to this court was whether the President can initiate the popular initiative and not who the promoter of the popular initiative was. That was done and dusted at the Court of Appeal and the High Court. And Mr. Wele for the BBI Secretariat yesterday tried to introduce that line of argument. I think it flies on the face of the rules of this court, because it was not part of what was submitted before you. And I think the most relevant things for them to have done is appeal on that factual issue. They never done. So the trajectory and line of argument that this court must adopt is whether the president can commence a popular initiative. There's no room for importing any other person to the equation. It's completely locked. And I do say that the High Court and the Court of Appeal did convince themselves beyond reasonable doubt that the Constitution Amendment Bill 2020 had all manner of footprints of the president in it, including how the process was initiated after the handshake, and actually to comment that Dennis Waweru and Junet Mohammed only jumped to the ship later on, and coming to say now that the BBI Secretariat is kind of an organization trading under this name. And I do note that that was a ploy to be able to give it a connection to an entity defined under Article 138 of the Switzerland Constitution that allow political alliances to initiate a popular initiative. But that, in our context, it flies on the face of it. Article 257 is very clear on how the process begins, and there are late efforts to lump two state officer and a member of parliament, because I do understand that at that time, Mr. Waweru was actually serving as a chair of Ken Invest. And Mr. Junet Mohammed, on the other hand, is a member of parliament, an active member of parliament, who the Constitution entitled to recourse to Article 256 to move any consequential legislation. And my lords, you note that the first appellant actually comes to this court not with clean hands. The Constitution is barely 11 years old. Article 27.8 that gives the state the mandate to operationalize things like the two-third gender rule, the judiciary fund, the equalization fund is still pending. And I think, I do agree that the life of any constitution, as alluded by professors like Richard Albert, is 19 years. It's the right of every ordinary citizen to move that amendment. And as the High Court and the Court of Appeal has held, Wanjiku has a right. The Constitution doesn't limit. It only limits constituted powers. And I think that must be understood. And with that clarity, I don't think that the first appellant and those in support will have any problem in now saying, for me to reluctantly say that the basic structure doctrine, in the case of Kenya, because the High Court, for me, introduced a new line of thinking on the basic structure issue. Because if you look at the basic structure in India, it completely locks the room for amendment by parliament and actually introduces issues of unamendable and eternity clauses. At around, I think, paragraph 472 or thereabout of the High Court judgment, the 5 judges are very emphatic and clear that all 18 chapters of the constitutions are amendable, and therefore, to the extent that they follow the basic structure doctrine and its applicability in Kenya for locking out amendments, I think leaves them to have misconstrued that decision. Because our understanding, and that of the third appellant, is that the finding was all 18 chapters and the 6 schedules of the constitutions can be amended. And on the first sequence process in relation to that, I think it's actually, I can term it as expanded public participation. I don't think there's anything wrong with the Constituent Assembly. It's just a fancy name. When you walk out of this gate, maybe some 4 years ago, you'll find the bunge la wananchi. That could be a perfect description of what a constituent assembly, and those gentlemen out here are very vibrant in discussing day-to-day matters that are germane to our legislation and governance system. And so I don't, it's not some rocket science thing, like a collection of views. Your lordships and ladyship have articulated that while discussing public participation in the British American tobacco case. And to Justice George Odunga in the Robert Gakuru case have also extensively expounded what public participation is. And so for me, the four sequence process do not shock me in any way. It's some form of expanded public participation. And as I had intimated, Article 10, which provides those principles and values, is now very important to the operation of our system and governance. Maybe just to pick a comment by Senior Counsel Kamau Karori on the issue of Liechtenstein and the Prince extending its term limits. To an extent, I see Liechtenstein not to be a good example because him alluding to a prince leads us to some monarchical side of system of governance. To that extent, I don't think it will provide a good comparison for comparative purposes because the Constitution provides that Kenya is a republic. And if, for example, I was to extrapolate the issue by the Prince of Liechtenstein on the term limits, I'm not sure whether anyone introducing extension of term limits in our current constitution, though they are entitled, the ordinary mwananchi is entitled to actually move such an amendment. But I don't think it is a perfect example just because of the system of governance. And we have been termed as one of the most progressive constitutional democracies now in the world, ranking with the likes of South Africa. And therefore, I think that example will not suffice. Just to touch something relating to the mandate of this court, while arriving at the verdict of this appeal before you. Earlier said that Article 259, Article 20 sub-Article 4, and to the extent, by extension, Section 3 of the Supreme Court Act, really outlines the interpretive theory of this court. Also, as in a gentleman by the name Miawa Maxwell does provide a good analysis of general theory of interpretation by the Supreme Court. And if I just quote, Article 20, sub-Article 4, Article 259(1), Article 259, and Article 259 lays down the rule of interpretation as follows: that the Constitution shall be interpreted in a manner that promotes its purpose, values and principle, advances the rule of law, and human rights and fundamental freedoms in the Bill of Rights, permit the development of the law, and contributes to the good governance. Justice Mutunga, if I quote his finding in his concurring opinion in advisory decision number 2, says that Section 3 of the Supreme Court Act confers broad powers and constitutional interpretation, allowing the court to make forays into the country history and cultures, to dig out the people's expression reflected in the text and spirit of the Constitution. So text and spirit of the Constitution. And Chief Justice William Mutunga further qualifies that these provisions grant the Supreme Court a near limitless and substantially elastic interpretive power it allows the court to explore interpretive space in the country history and memory, and the history and memory that appeal to your lordships and ladyships is our history. After we got independence, till such a time, I think, around 1997, because 1997, the Kanu regime had already given room for the people to come to the negotiating table. So I think that history, and I will refer you to the writings of Ben Abweze in Presidentialism in Commonwealth Africa, and a book written in 1984. I think the president of the LSK will mention, he has cited extensively in his submission. Abweze actually writes about Kenya in that book, and the question of hyper-amendability and the powers of the imperial presidency. And actually, just to recall that in 1968, an amendment was moved by the president to take away the powers of parliament to nominate, I think, around 12 members at that time. And that mandate by parliament was actually revoked, I think, in a single afternoon. Same to the 1982 scenario of introducing a one-party rule, or even 1988 where security of judges, 10 of judges was taken away. I think those are some of the fresh memories that really should tinker in the mind of anyone reading and interpreting this constitution. So Justice Mutunga says we can't run from that history. And what the first appellant and those in support of his position are telling you is that let's close our eyes on where we came from and focus the textual provision. And I didn't submit that the textual do not favor in any way the president commencing a popular initiative. It doesn't. And if you will allow me to read Article 255, Article 255, and read together with Article 257, and this just serves to show that the text is very clear. Reading it with Article 1 on delegated powers and the Constitution as a contract to the constituted powers. 255.3 says that an amendment to this Constitution that does not relate to a matter specified in Clause 1 shall be enacted either by Parliament in accordance with Article 256 or by the people and Parliament in accordance with Article 257. Sorry, I think I'll take it back. And that my finding is that the text of Article 255 is only a preserve of the people with Parliament. The people commence the initiative under 257 as a form of a general idea, and that they must be the promoters, not a state officer, and follow all the steps outlined under 257, including having it debated at the county assemblies and the different parliaments, Senate and National Assembly. So the history text do not support any departure or do not allow any room for this honorable court to infer that Article 255 can be amended by the constituted powers, including other state officers. And by extension, I'll also refer your lordships and ladyship, the Supreme Court of India in Reserve Bank of India versus PLS General Finance and Investment Company Limited, the 1987 case, again reiterating the issue of interpretation of the Constitution. That interpretation again must depend on the text and context. This means that this court has to go beyond that textual provision of the Constitution in determining the applicability of the basic structure in Kenya, either the BOMA's draft, the WACO draft, revised harmonized draft, that shows that the intention of the people was very, very clear. And it has also almost been produced as a copy-paste under Chapter 16. The framers of the 2021 Constitution, which subsequently have been adopted by the people in the preamble saying that we the people, had the overarching goal of undoing all those loopholes between period 1964 and 2010, when the Constitution was ultimately promulgated, that befallen the previous Constitution. And that actually takes me to the finding by Justice Lenaola, then the High Court judge in the Commission of Implementation of the Constitution versus National Assembly, a 2013 case, saying that the judges have a duty whenever the identity and architecture of the Constitution is under threat. Today, that problem again is before you, and following the dictum by the Honorable Judge, this Honorable Court has the duty to protect the architecture and design of our Constitution. And the duty is given to you by the people of Kenya under Article 1. And I just want to laud this, the whole judicial system, that despite the challenges they face in obedience to the court orders, which orders shall never be given in vain, I think post-2010, the judiciary has been one of the most reliable and the beacon of hope for the people of Kenya. And let me just randomly mention the Security Laws Amendment case in the first term of the Jubilee government that seeks to sweep most fundamental rights under Chapter 4, under the carpet. And I think the bench, I don't remember if it was a 3-judge or 5-judge bench, then rallied in defense of the Constitution. And my clarion call is that you, Honorable judges or justices of the Supreme Court, must also protect the Constitution for posterity. And if I may refer you, your lordships and ladyships, to the wordings of the preamble, which is, I think, very unique, and also coming at the very, very beginning of the Constitution. In the preamble, the people says, we the people of Kenya adopt and enact and give this Constitution to ourselves and to our future generations. We adopt, enact, and give the Constitution to ourselves and to our future generation. For me, the issue of future generation is very key. It's a very, very key word. That the intention of the people was that you can amend, not fundamentally, maybe issues of issues not ring-fenced under 255, but let's try and keep it for the future generation. The Constitution is 10 years old. If a child was 10 years old, I'm not sure if they're actually in a position to start actually eating things like getheri. This Constitution is still trying to develop it's teeth. It's not even a teenager, strictly speaking. And I think the solemn duty of the president under that schedule will have been to preserve, uphold, and respect by operationalizing, among other things, the two that gender rules, the judiciary fund, the equalization fund, rather than spend a whopping 20 billion taxpayers' money for purpose of amending the constitution. Or I wish if that money was actually allocated to the judiciary fund to give room to more small claims court or building infrastructure for either the judges or courtrooms. That would have been my ideal wish. And this court may get persuasion of the phrase "we the people" by seeing as in it's also provided under the U.S. Constitution and the Indian Constitution. And interestingly, as in I found that the U.S. Constitution, despite the fact that it has been since its conception in 1787, 235 years ago, the people have only amended 27 times. We in Kenya, the constitution is 11 years old. We want to move a whopping 83 amendments in a record 2 years to make it worse in the middle of a pandemic, such that the review by the people and even the collation of views becomes an uphill task, and you just sneak the constitution under the tunnel and purport to legitimize it by saying that, look, the only requirement for us is if it has the backing of 1 million voters supporting it. I think that is not what is intended. That is actually putting the cart before the horse. Because in presidentialism, if we got it wrong at the promoters level and a book written in then it is null and void, ab initio. I think the president of the LSK will mention he has cited extensively. My lords and my ladies, as I mentioned earlier in his submission, Justice Ringera did infer the sanctity of a basic structure in a constitution, in the independence constitution. I think I can't fathom any finding under the 2010 constitution that holds otherwise. Just as a response to Senior Counsel Paul Mwangi, the basic structure is an unruly horse. And actually George Gilbert, to an extent, saying that the Superior Court did fail in not indicating what the basic structure is. And I'll direct him to paragraph 471 under F, where the judges clearly outline what the basic structure is. So I think it is unfair to fault what is actually provided in the judgment of the court. And they go on and say it's all those features that are foundational, so important to our nation. And to an extent, they also mention things like supremacy of the Constitution and sovereignty. I do agree it's not a close list. The articulation of what was the basic structure was not closed. But I think it's unfair to say that the High Court darted all over the place in trying to say what the basic structure was. And to Senior Counsel Paul Mwangi, I don't think the basic structure is an unruly horse in the case of Kenya. As I had said, the basic structure as interpreted by the Superior Court judges departs from what the basic structure in the Kesavananda case is. Mainly because, unlike India, which do not allow room for amendment, our basic structure provides room for amendment by the constituent. I think that is a clear departure. And as such, having identified then what the basic structure is under 255, I don't think then the issue of unruly horse should arise, because I understand the unruly horse as a phrase originating from Justice Ringera in the Christ of All Nations case was Apollo Insurance Company. And I think he was alluding to public policy being a concept without a province of what really could be termed public policy or the subjectivity of it. The Superior Court and the Court of Appeal have clearly closed our boundaries on what the basic structure is. And therefore, I don't think there is room to term it as an unruly horse. My lords and my ladies, I just want to seek clarification on the time, because I think we were given some 20 minutes.
You have already taken them. If you watch the clock, you are given 1 hour, 18 minutes. Now you are remaining 35 minutes.
I think I'll just close by very fast outline, submitting on the popular initiative. And I could actually do it in form of a rebuttal, because other parties will have a chance to submit on. That to rebut on Senior Counsel Kamau Karori on the president campaigning, he said that the president can actually campaign on the platform of amending the constitution. I think that is absurd and flies on the face of the third schedule on the other office of the president. And actually it overrides its right under Article 38 of the on political rights, because I had intimated at every election we get the governed and the governing, and what we have is a contract such that the president cannot be held to be crying, saying that his political rights have been amended, while in real sense, he's actually the one on the other side of the table supposed to guarantee enjoyment of that right by citizen. So I'll just picture a picture of a president carrying a bangle along parliament saying, look, as in I have a right to demonstrate, just like any citizen, entitled to these rights under this constitution. And the issue at stake is my rights have been limited. It's an absurd finding. That means he can only get to such a position by relinquishing his authority as a president. And I allowed our president because he has set that trend in 2014 during the ICC trials. He had that audacity of actually stepping out of his privileges and saying that I'm going as an individual. That means the route of Article 257 is only available to that ordinary mwananchi. That person waking up in the wee hours of the morning from Kaongware Kangemi, when the bus fare is still Kenya shillings 20 bob, to come to a construction site in Westland, I think is what is envisaged as the ordinary citizen who can initiate a popular initiative. It's not a state officer with all the trappings of power and sitting on a back left of a German machine seeking to amend the constitution for selfish reasons. There's a conflict clearly. And that conflict was also articulated again by the High Court in envisaging the dual role that the president will have if he was allowed to move amendments to the constitution. That I'll be promoting the constitution as a president. That means that those are my own views. And at the same time, I'll be the one assenting. I think that finding is absurd, and conflict of interest is written all over it. Therefore, I don't think the Article 38 issue should never arise. It's a social contract. For the 5 years, he is a duty bearer. He's supposed to guarantee he can't have a room to cry as a baby, saying that I want to amend the Constitution. More so, the entrenched clauses. That should not arise. Mr. Moke will rebut the issue of referendum question. We have extensively submitted on that in our submission, and quite interestingly, the IBC, which was supposed to respond, just slap us with the argument of the doctrine of ripeness. I think Mr. Morara will debunk that. On Professor Githu Muigai comments on IBC powers, I think it can be varied. But again, Article 255 protects IBC and all other independent commissions under Chapter 15 whenever there is independence is at risk. So I think that must be taken with caution, because I believe IBC is also one of the commissions under Chapter 15. And whenever its independence is at stake, just the way this court independence was at stake with the creation of the Judiciary Ombudsman, then the hands of the promoter are locked. Senior Counsel Kiragu Kimani cites Article 138 of the Swiss Constitution. No evidence was adduced whatsoever showing that a president or any other state officer can actually move amendments. And I will refer you, your lordships and ladyship, to paragraph 57 and 58 of volume 21 at page 3027, where we clearly discuss the issue of Article 138 of the Swiss Constitution. It's not a state officer or a president that is envisaged. It's not. In fact, scholars writing on that issue alludes to the issue of direct democracy and popular initiative. One of the definitions given by the Black's Law Dictionary, it's the people exercising their own residual power in a direct way, not indirect way. And paragraph 58 of volume 21, we say that according to Article 138 of the Swiss Constitution, all popular initiatives are driven by ordinary citizens as a form of direct democracy. And this actually originates at the local and canton levels. I'm sorry to take you back, my ladies and my lords, but under the CKRC report, the people say that our constitution should actually be amended the way it was made. And that, I think, introduces a very high threshold. And I'm sorry to use this word, but under the same report, page 42 of that report, the people had this to say as a recommendation, that one very interesting is the provision of structures of the review process to reflect the bottom-up approach. I know that that's a very sensitive term at this, but those are not my words. They are clearly provided under page 42 of that CKRC report. But then going back to your issue of interpretation, looking at the context and the history, the intention of the people that was in amending what is so fundamental to them, we must start at the bottom, and it comes up. That means now with the involvement of the Constitution, the County Assembly, Parliament, and all other relevant entities like the IBC. But it should never be seen to be something that is being proposed at the top. And that's why I was saying that the process of amendments introduced by the Constitutional Amendment Bill 2020 was wrong ab initio. Based on that intention and context by the people provided under that CKRC report. For the interest of time, and for the sake of my senior Mr. Morara, I just want to say that the post the 1997 IPG, where the people actually agitated for the People Review Commission, you can deduce that there's a process and procedure of amendment of the Constitution and the content of the Constitution. Process referring to the popular initiative, parliamentary initiative, and content referring to what I can term as entrenched clauses. So I think that must really be considered. I've referred you, my ladies and my lords, to the Black Law Dictionary of meaning of popular initiative. And I'll not dwell further on the writings by Professor Richard Albert or Yaniv Rosnai. I think Mr. Nelson Harvey will do that. And I'll close by saying that my clarion call to the first appellant and those in support is for them to end the hostilities against the Constitution. Though we recognize them as prisoners of war based on the findings of the High Court and the Court of Appeal, and that us on the other side will be willing to make peace with them and preserve and uphold the Constitution of Kenya. For the interest of time, let me yield the floor to Mr. Omoke. But before that, I just want to acknowledge the presence of my Professor Ben Sianya, who actually provided me a platform at the formative years at the School of Law in Parklands to be his researcher for 3 years in constitutional law. I think it's fair credit for me to recognize him at this forum. So I would like to yield the floor to Mr. Morara. We had a lot to submit, but for the interest of time, I would like to stop there. Thank you.
Honorable Justice of the Supreme Court, I'm very honored to appear before you today. Thank you for the opportunity to hear our arguments. I'll begin with the issue of quorum. When I was filing my petition before, my name is Morara Omoke, I forgot to say that. Morara Omoke, the third appellant, and I was also the petitioner in E416 before the High Court and the 76th respondent before the Court of Appeal. Before I filed my petition at the High Court, I read very carefully the decisions that were surrounding questions on quorum of the IEBC. And in my mind, there was no problem with what I found and what I was seeking the court to find. I was asking the High Court to find that the IEBC lacked the quorum to conduct something very important, which I consider to be a policy issue. When I looked at other decisions like the Isaiah B. Watt case, which has been cited very extensively by the IEBC, I looked at that and I found that, in my opinion at the time, the law applicable was the law that was there before the decision in Katiba Institute, which set the quorum for the IEBC. When you look at the Constitution, there's Article 251, which has been relied upon by the IEBC to identify what they consider to be the quorum of the Commission. And I would like the Supreme Court to distinguish between quorum and composition, because what we have in the Article 251 is the composition. The minimum number of commissioners required to be properly constituted, which is 3. But quorum is a different question. It's about the functionality, the day-to-day operation of a commission and decision-making. You cannot ignore quorum, because if we say that we operate without quorum, then that would be very dangerous. And we know the role that the IEBC plays in our country. It's basically something that goes to the core, to the stability of our nation. The elections, we cannot have a commission that does not have quorum. When we say, if we go by the argument of Professor Moigai, then we are suggesting that quorum in that case would be 100% for the 3 commissioners. If we operate with a commission of 3 commissioners and we are conducting an election, very, very sensitive, and something happened to one of the commissioners, what would have happened if we were conducting an election? What should happen at all times is that the court should not entertain a situation where the commission is not properly constituted. It should come out very clear that at all times, the commission should, as much as possible, be at full capacity. Because for the IEBC, we must also ensure that the composition also reflects the diversity of our people. It's not something where we could appoint 2, 3 Kenyans and we assume that it balances the entire republic. I'll move to give an example. If we operated, going by Professor Moigai's argument that when if there's a repeal in the case as he suggested, that we would have no law. Let's take an example. If we had an amendment to the tax code, repealing the current tax rates and providing higher tax rates, and that was challenged at the courts and found to be unconstitutional, can we actually argue that then we would be in a country where we do not pay taxes until the parliament enacts laws providing for the previous tax rates? That argument would not be good public policy. I move on to the next question on the composition, the second schedule to the Constitutional Amendment Bill of 2020. To me, that was very straightforward. I did mention it in my High Court petition, but I did not consider it to be a very complicated question. And I would ask the court to easily find that under Article 89, already there's a provision for how to delimit boundaries, and the timelines are provided within a duration of 8 to 12 years. That has not been done. So there was no mandate for the BBI, the Building Bridges Initiative, to do that particular responsibility on behalf of the IEBC. I move then to the question of public participation. A lot was said in the High Court and before the Court of Appeal. That may not have been highlighted before you, but in a very short summary, what was found is that the promoters, who we argued then was the president, did not comply with the procedures set out in the Constitution in terms of public participation. It's very straightforward. What happened is that initially they went around the country, views were collected, that's all okay. Of course, we saw some problems with that, how it was done, because basically what was happening is that those collecting views moved from town to town in the Republic, collecting views in 3-star and 5-star hotels. Obviously, who is going to be in those kind of fora? That kind of fora, it's the elites, the poor or the ordinary, what I would call, I wouldn't use the word poor, but what I would say as the everyday Kenyan may not have that access to give their views. So that was one of the areas where they failed. But more importantly, when the bill was published for the purposes of now collecting signatures, that was on 25th of November 2020. And the signatures were collected from the next day. So there was not opportunity to educate the public on what was contained in the bill. Another problem which was highlighted and accepted at both levels of the High Court and the Court of Appeal, which has not been challenged, was that there was no consideration of because it was done, the publication was done online. There was no effort to consider the internet connectivity in our country, which when I look at the Kenya Population and Housing Census report of 2019, volume 4, was found to be 22.6%, and the access to computer was 10.4%. So if you do it online, automatically you lock a major a vast majority of the people from being able to see the bill before they collect the signatures. And if you do it the next day, it means you do not care for whether they were given the opportunity. And if you look at the decision of this court, the British American tobacco case, you gave us the guidelines that we must look at when we weigh an action that has been undertaken to see whether it meets the threshold for public participation. When you look at that case, there was basically what is then happening in that case is what you would say is illusory. What is politic? What is not, does not give the public reasonable opportunity to study the bill before they can give their consent, before they endorse. So what that means is that for the 4.4 million signatures that were collected, they were of no value because a vast majority of those people were just signing before studying the document. When you look at the amendment bill, it contains about 74 clauses. Even for us who are the experts in the law, we may need some time to study those kind of provisions before we give our views. And that's why when we were able, you could see even from the filing of the petitions before the courts, people took time to study those provisions. So you could not conclude that doing it under 12 hours of publication is enough. There's a lot I could highlight there, but I think that's enough just to show what exactly happened. When it moved to the IEBC has argued that they do not have any responsibility to ensure compliance with public participation. That is wrong. When you read Article 10, it imposes on all state officers and all, even the commission, being one of these institutions required to comply with Article 10. Those are values that must always be reflected in their decision making. So when the signatures were brought before them, the first thing they should have done is to consider whether there had been public participation. They had that responsibility. They had to consider if on their part they have actually conducted, there was civic education before they process that. And that's a responsibility that solidly lies within the jurisdiction of the IEBC under Article 88. So on that question, the court should easily find that there was no public participation, should not entertain any argument to the contrary. I will move then to the issue that is before us in my appeal. The appeal which seeks to an interpretation of Article 257.10 to establish whether indeed in our country we should be having more separate and distinct referendum questions. I'll begin by laying a foundation based on the judgment of the Court of Appeal. When the judgment was delivered on 20th of August, I listened very keenly to the analysis of each of the judges, and indeed when the judgment was availed to the parties, the hard copies and the soft copies, I read, and my conclusion was that there was an error in the tallying of the final vote of which judge voted to uphold or overturn that finding. So when I looked at each analysis, my view is that, as I agree with Justice Ouko, that it appears that there were 4 votes to uphold the finding of the High Court. So to be diligent, I did send correspondence to the Court of Appeal. I wrote a letter dated August 25th, 2021, which I dispatched to the court on the same day via email. And I received a response. Rather, I sent it on 24th of August, dated 24th of August. I received a reply on 25th of August. The letter was addressed to the President of the Court of Appeal, and I was very respectfully asking him to look at the tally. And I gave grounds, and I pointed out what I thought was what was contained in the judgment, and why I think the vote should be 4-3 in favor of upholding that finding of the High Court. In his reply, he said, which was conveyed to me by email by Registrar Lorraine Ogombe, was that the view of the President was that there was no error. The reason I did that is I did not want to saddle the Supreme Court with an unnecessary appeal if indeed that was an error. So having satisfied myself that I've taken the right steps, I approached the Supreme Court through the appeal that is before you, appeal number 11 of 2021. So I did that part, and I think the court can look at the analysis and easily reach a conclusion that that finding of the High Court should be upheld. But I'll not rest there because it's important for the Supreme Court also to hear what is the justification for seeking that kind of a finding. I'll ask the court to read the text again. I know we've read many, many times Article 255 to 257, but I'm asking again, all of us, even my opponents, maybe they might be convinced when they respond to me, especially the IBC, which is there to respond. I would like to read, I did draw a table, which is in my submissions at page 8. My submissions are dated 24th of November 2021. In that table, I tried to do a textual analysis of the words in Article 255 to 257. I looked at words that I used there carefully. I saw a word called a proposed amendment, the amendment, an amendment, a bill to amend this constitution, the bill, any bill, a general suggestion, a formulated draft bill, a draft bill, the draft bill, a bill, and there was a word again repeated at the very end, the bill, which I've just drawn them just to try and analyze, because we seem to be all in agreement, the parties before you, that it's important to look at the textual analysis. So when I do the textual analysis, my conclusion was that the way the words have been used by the Constitution in those clauses can only mean that they are used in a singular form. Also suggesting, therefore, that when we prepare a draft bill to amend the Constitution, it ought to contain a single amendment. But if there is a need to contain anything more than one, it has to be something that is consequential, that arises from that amendment being made. Because it happens, you could amend one section and it touches on another one. But the primary amendment should be one. So that's why I want us to start on our analysis when we, hopefully I am praying to the court, when you do the analysis, to begin at that point, which will then assist us to reach a conclusion that a draft bill should contain one issue or one amendment. However, if the court also looks at that, it should not rest at that point. Also look at the findings and see that if an amendment is just one amendment, then when we go to the referendum, the voting should be on the amendment, that single amendment, in a way that allows the people to select just one item at a time. There is a possibility when you do an amendment, you may have then what I'm calling the referendum questions, whereby just a single amendment elicits the need to get responses from the people on more than one issue. I'll give an example. If there was an amendment to alter the presidential term, that kind of an amendment will require some responses from the people. Do we agree that we should alter the presidential term limit? That will not end there. We may need also to hear from them. Do you want to increase it? Do you want to increase the term, presidential term, or reduce it? Then there will be another question. How should that amendment be? Do we have a 5-year presidential term or 4 years? A 5-year term that is, and then is someone entitled to getting one term only? So you can see that just one amendment can lead to more than one referendum question. So what I'm asking the court, by looking at my prayers, the main prayers in my petition, if the court can reach a conclusion that we should have a draft bill with one single amendment, it will be able to resolve the problem. If we have an amendment that is framed in terms of the distinct referendum questions, that will be able to deal with the problem. This issue that is before you is not theoretical, it's not speculative, it is based on a real issue. Before you, what has triggered the litigation, at least for all the petitions before the High Court except one, was the fact that there was an amendment bill, what we're calling the Constitution of Kenya Amendment Bill 2020, which, as we've said, contains 74 amendment clauses, but there could be many more amendments. If you analyze each and every clause, it could generate more than 74 amendments. So therefore, when I approached the court at that time, I'm informed by Article 22 of the Constitution that if I can, as a citizen who is doing his duty under Article 1, and Article 3, Article 1 and 3, to defend the Constitution, I have to approach the court and say, I am feeling that there is a threat on the Constitution, because if we conduct this referendum, we end up with a yes or no question on 74 amendments. It's dangerous. It's not good for the country. It will decimate the Constitution. And I'll give examples. When I looked at the amendment bill, as a citizen who is taking a vote, I'm just going to pick a number of examples. I saw a provision allowing a tax break. I would be very happy. And I think any entrepreneur out there would be happy to get a tax break. But as an advocate, I found another provision telling me that if we pass the amendment bill, then I cannot conduct election petitions until when beyond the Court of Appeal. That litigation ends there. And I found that is a limitation on the rights of those who litigate, because the provision is there. Matters of political rights should not be limited. As a litigant, they should be able to get the opportunity to litigate to the end. As an advocate of the High Court representing them, that's my trade. I should not be limited to end my litigation in the Court of Appeal. When will I appear before you, Honorable Justices of the Supreme Court, if we end all the litigation in election cases at the High Court, at the Court of Appeal? So I'm concerned I cannot accept to vote for that kind of an amendment. But I am seeing the tax. So I'm being put in a dilemma as a citizen when I'm taking a vote on that kind of a bill. I look at other dangerous provisions that would have totally destroyed our judiciary, like the judiciary ombudsman, which was dangerous for our country, not just for the judiciary. So basically then I would like to highlight other provisions of the Constitution which should aid the court to reach a conclusion that we should always have separate, distinct referendum questions, and we should have a draft bill only raising, or rather containing only one single amendment. We begin with Article 32, which gives the people freedom of opinion. You are entitled to form your opinion, but if I'm given 74 amendments all in one document, what opinion will I form? If I have to still express my decision at the end, having been given more than 74 contradictory, confusing provisions, some of which I agree with, others which I do not approve of. I go to Article 33, freedom of expression. If you give me all of them in one document and you tell me to express my freedom of expression, I will not be able to exercise that freedom. If you give me this in a vote, Article 38, my political rights, when I'm seeking to vote as a citizen, and I'm just given all the options tied in on one ballot, it cannot be in line with Article 38, where I'm told that in Article 38, my freedom, the right to vote includes being able to vote in a way that, to be able to express my will in an election freely. It cannot be free if it is like that. Then I go to the general principles for the electoral system of Kenya at Article 81. They have been laid out. What are the principles? That the electoral system should be able to enable simple voting, efficient voting, voting that is seen as transparent and accountable. It cannot be transparent and accountable if you get 74 amendments and you are voting in one. It's like, I'll use a simple analogy. If we were to be given the 6 ballots that we usually do in our general election, and you're told you have all your presidential candidates, they are in one ballot, or rather they are classified, and you're told you have this presidential candidate and you have this member of parliament, all the way from top down the ticket, vote only once. How is that going to be, how does that sit with the Article 38 and Article 81? So basically what I'm telling you, the justices of the Supreme Court, is that the issue of the format of referendum questions and the draft bills, it strikes the heart of the Bill of Rights. And when you interpret the Constitution and Article 259, then you have to look at that. You have to look at whether the kind of thing that is before you will it enhance human rights, will it enhance fundamental freedoms of the people. As I come to closing this presentation, I would like to urge you, the justices of the Supreme Court, that what we are doing here is something, basically a point of inflection for our country. And as President Joe Biden usually says, it's on us. It's on you, the justices. it's on us, the advocates and the people, to comply with the clarion call in Article 3 of the Constitution, that we have to ensure that the Constitution is respected, upheld, and defended. I thank you, judges, and in case there's any question you would like to ask me at this point, I would be happy to take it, or I'll take it at a later date.
Thank you for your submissions. I think we'll reserve the clarifications later.
Thank you, Honorable CJ.
Yes. It is now 1:20. We will take a lunch break and resume at 2:30 to hear from the respondents. 2:30.
As we break for lunch, my name is Ochiel Dudley. My lady, I just wish to clarify a really small and harmless report I've seen in one of our dailies concerning yesterday's proceedings. I have seen it reported that 2 advocates sought leave and were granted permission to withdraw from the proceedings, and that Ochiel Dudley was one of those 2 advocates. I just wish to clarify, my lady, that Ochiel Dudley did not seek permission to withdraw and did not withdraw. He remained seated yesterday and has attended today as he will tomorrow. Most obliged, my lady.
Thank you. That is well noted.
Thank you, my lady.
2:30.
Indeed, those are some of the remarks of some of the oral submissions being made there at the Supreme Court. The hearing, enters day 2 of today, and also applicants want opinions on whether the Constitution be changed by 4 steps, including civic education, public participation, assembly, debate, and referendum. Some of the BBI issues stated there include the basic structure, doctrine, and its applicability in Kenya. We have definitely had with some of the remarks made by Morara or Moke, stating that the court should refine that there was no public participation involved in regards to BBI, saying that no efforts were considered in regards to internet connectivity in the country. Also stating that BBI did not meet the public threshold for the public to be given more time to study the bill before it was endorsed, and many Kenyans definitely signed it without a proper understanding, stating that in matters of BBI it did not get to the grassroots level for the common mwananchi. Also in regards of the basic structure, earlier on we've seen some statements made by Professor Githu Muigai, stating that basic structure means the part of the Constitution that can't be amended because it is specially protected from Parliament and it operates in parliamentary systems. Also, Isaacs, on that same matter of public structure, Doctrine said it is in conflict with the Constitution as it challenges legality and validity of Article 1 that includes the sovereignty of the people. We're definitely